Brown. Here. Carter. Lewis. Williams. We have 4.
With 4 members present, we do have a quorum. I'd like to make a motion that we move into executive session on Senate Bill 103. Do I have a second? Seconded. Thank you, Senator Bean. Is there any discussion on the bill? Seeing none, I now move for the adoption of, or I guess for the passage of Senate Bill 103. Madam Secretary, please call the roll.
Second.
Oh, I need a second.
Second.
Thank you, guys.
All right. Senators Coleman.
Aye.
Hudson. Bean.
Aye.
Brown.
Aye.
Carter. Lewis.
Aye.
Williams. So we got 4-0.
By your vote of 4-0, Senate Bill 103 passes. I'd now like to make a motion to move out of executive session.
Second.
So moved. Thank you. Okay, so a little housekeeping before we get going on the bills. Senator Schroer has another obligation, and so do I, but we also have the Tax Commission who's come in to testify, and we have a little bit of housekeeping measures to talk about first. So we're going to start with some housekeeping measures, and then we'll let Senator Schroer present his bill, and then we'll talk to the Tax Commission, and then I'll present mine at the end, so that way we're able to kind of keep things going. So a little bit jumbled, but hopefully we're being respectful of everybody's time. All of the members of the committee should have in front of you a chart that is a summary of the suggestions that we've gotten. Our portal went live last week with suggestions from the public about ways in which Missouri could improve the efficiency of services rendered to taxpayers, eliminate duplication and waste. Okay, great. So we have had in the first week over 1,600, and well, actually 1,673 suggestions that have come in. We are not distributing all of those. Some of those are political in nature. Some of them are grievance-based that are not appropriate suggestions. Some are in response to specific bills. And so what you have is 70 roughly responsive suggestions. So we're going to print those out every week for the committee so then we can kind of guide where we're looking. By and large, the number one issue that of the responsive suggestions that have come in have been about wasting disease for our testing with Missouri Conservation Committee and how they're handling the deer population. People are really, 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 really angry about the way that program is being handled, and so we certainly are going to add that to the top of the list to be looking into. If there's a committee member who sees something else that they want to kind of reach out to, let us know. We took off the email and all the names and all that information on this document. This is going to be posted in the committee notes, so if anybody's paying attention and wants to read what those responsive rates are. My plan at this point is that we are going to, on a weekly basis, save all of the emails that came in the last week, put them on a zip drive or a thingy, and then we're going to delete from our system those documents. So if there's a sunshine request and people are wanting to get access to that information, it's widely available. And then distribute to the committee this summary of documents on a weekly basis. If anybody would like my office to handle these responses differently, now would be a great time to tell me. Okay, seeing none. So if anybody wants to see the full list from last week, 1673, let us know. We're over 2,000 responses now, about 70 kind of more substantive responses, and we'll see how things continue to go. With that being said, Senator Schroer, if you'd like to come forward, I'd like to make a motion that we begin our hearing on Senate Bill 221. Senator Bean, do we need a second for that? You don't need a second for that. Okay, we're good. Senator Schroer, begin when ready.
Thank you, Madam Chair, and I assure the committee it was not me pulling the fire alarm. I was in the other room. I was ready for the hearing. For the record, Senator Schroer, Senate District 2, on Senate Bill 221 relating to judicial non-deference. For decades, the doctrine of Chevron deference has led the courts to yield to administrative agency interpretations of ambiguous statutes, effectively shifting power away from the judiciary and creating a quasi-fourth branch of government. In a landmark decision, the Supreme Court in Loper versus Raimondo decisively rejected this misplaced deference, underscoring that when agencies merely apply law to facts, courts must independently interpret the law. This ruling reaffirms the judiciary's exclusive role as the ultimate interpreter of the law and serves as a call for Missouri to restore the fundamental balance. As sponsor of this legislation, I bring to this discussion a blend of experiences from my legal career as well as my extensive service on the Joint Committee on Administrative Rules. These roles have provided me with deep insights into how our administrative agencies operate and the importance of maintaining a balanced and accountable regulatory framework. It is with this background that I approach Senate Bill 221, firmly committed to upholding the constitutional principles of fairness, accountability, and the separation of powers essential to our representative government. Missouri case law presents a mixed picture regarding judicial deference. In Burlington Northern Railroad versus Director of Revenue in 1990, the Supreme Court of Missouri mandated that courts exercise independent judgment to correct erroneous agency interpretations. Subsequent decisions, however, such as Pinion Investment versus Boyd, Kansas City, we've got the State XREL Public Counsel versus PSC, Hallman versus Missouri, that was the most recent one in 2018, have all shown a trend toward deference, placing a high burden on challengers to overturn agency decisions. SB221 seeks to clarify this inconsistency by requiring an independent de novo review in cases where agencies are simply applying clear legal mandates to undisputed facts. Missouri's administrative agencies have increasingly overstepped their mandate by not only creating rules, but also securing judicial validation through deference. This dynamic transforms agencies into hybrid entities that perform the roles of all three branches of the government, legislative, executive, and judicial, without accountability that comes with the democratic oversight. SB 221 is a direct response to this challenge. It reasserts the constitutional duty of our courts to independently review agency decisions and ensures that the role of policymaking remains with the legislature. In closing, SB 221 is a necessary step toward restoring and safeguarding Missouri's constitutional balance of power. By mandating an independent de novo review in cases where the law is clear, this bill ensures that policymaking remains the prerogative of our elected legislators and that of our judiciary remaining impartial. SB 221 protects individual liberty, upholds the rule of law, and preserves the accountability that is the cornerstone of our democracy. I urge my colleagues to support this measure so that Missouri continues to stand as a beacon of constitutional integrity and democratic governance. Thank you.
Thank you, Senator Schroer. Any questions for the bill sponsor? Seeing none, can I just get a set of hands? Who's here to testify in support? Who's here in opposition? Anyone for informational purposes? Okay, great. Go ahead and come forward, please. Thank you so much. And if you didn't fill out the witness form online, if you'll make sure you leave one and just introduce yourself for the record.
Absolutely. Thank you, Madam Chair. And I do have copies of my testimony if the committee is interested. Thank you, Madam Chair and committee members. My name is Colleen Lindgren. I'm Legal Policy Manager at Pacific Legal Foundation. The foundation is a nonprofit public interest law firm that has litigated over 2,400 cases on behalf of clients whose constitutional rights have been violated. 18 of these have been U.S. Supreme Court wins, many of them in the issue area that brings us here today on this bill, which is separation of powers. Articles 1, 2, and 3 of the U.S. Constitution, which was ratified in 1787, contemplate three distinct branches with unique but complementary powers and goals. In 1820, the people of Missouri did the same when establishing this state's constitution, specifically in Article 2. Neither our nation's founders nor Missouri's could have imagined the widespread overturn of duty that many branches of government have given administrative agencies in the past century. Some even refer to this as the fourth branch of government, or the administrative state. But agencies are just tools to carry out legislative intent. They are not lawmakers, nor are they equal to any branch. So a vote for this bill, for Senate Bill 221, is a vote to make clear that what the founders of our country and this state would have believed was evident, that the agencies and the government should not be given preference under the law. In showing deference, judges abdicate their duty to only say what the law is, not what they or others may think it should be. Judges also fail to render independent, impartial judgments when they put a thumb on the scale in favor of any party. So this subverts the adversarial system of adjudication that has been central to the American legal tradition for centuries. Judges must not only hear both sides of a case before making a decision, they must listen without systematically favoring any party. Deference to state agencies has been increasingly criticized, and the U.S. Supreme Court issued a decision last year ending deference to agency interpretations of statutes. And that's one of the case that Senator Schroer just spoke about. In recent years, states have begun ending improper judicial deference through state Supreme Court decisions as well as legislative action, and Missouri should join this trend toward fairness under the law by adopting SB221. Among the states that have adopted recent reforms are Arizona, Florida, Indiana, Nebraska, and Tennessee. They've amended their laws to protect the separation of powers. And in closing, I think Chief Justice John Roberts said it really well in his confirmation hearing about 20 years ago when he addressed this issue. He said, judges are supposed to call balls and strikes, not pitch or bat. So by passing this bill, the Missouri legislature will be doing its part to uphold the framers' vision for checks and balances, as well as the Missouri Constitution's promise of separate but equal branches of government.
Thank you for your testimony. Any questions for this witness? Seeing none, next witness in favor, please come forward.
Good afternoon, Madam Chair, members of the committee. Thank you for allowing me to testify today. My name is Steve Johnson. I'm with the Center for Practical Federalism, where we are big fans of federalism, the constitutional framework where some powers at the federal level, but far more with states, communities, and the people. We'd like to add our support to Senate Bill 221. There's been some great points made. However, when we look at legislation, I want to provide a different perspective. We look at it through the lens of how does this protect your state from federal overreach. So we actually put a scorecard together. You guys have this scorecard. I've got extra copies if anyone wants to see one. And we ranked states on what policy do you have to protect yourself against federal overreach. You'll see on page 10, Missouri ranks at 27th out of 50. So you're kind of middle of the pack, room for improvement. If you go to page 6, you'll see that second column is judicial non-deference. And that's the issue before us here today. And you might ask, what does a state court deferring to a state agency's interpretation have to do with federal overreach? And it's a fair question. The reason is that federal agencies coordinate with state agencies all the time. Many state regulations are due in part to federal law. For example, Medicaid regulations, a lot of environmental regulations, think Clean Air Act, National Environmental Protection Act, some educational requirements. There's a whole host of regulations that exist either because the federal government strongly encouraged it or actually flat out required that. Now, when the United States Supreme Court ruled in the Loper decision saying federal courts are no longer going to defer to federal agencies, that doesn't affect state courts. And as you can imagine, understandably so, state agencies will often defer to federal agencies' interpretation of the law when they're dealing with these issues. So we have a situation where without this legislation, you have a state court that isn't just deferring to a state agency, but oftentimes deferring to the federal agency's interpretation that oftentimes isn't actually grounded in law. So that's where we see this legislation as being very important at protecting Missouri and the people of Missouri from that federal overreach. No state court should weigh the opinion of a federal bureaucrat more highly than the opinions of the people of this state. And that's what this legislation accomplishes. So there's a lot of good arguments for it, whether you want to make sure you're running in the administrative state, you like good judicial process, those are all good. But we'd also like to highlight this legislation is key to protecting your state and the people of your state from undue federal influence. So with that, I'll close my testimony. If there's any questions, happy to answer.
Thank you for your testimony. Any questions for this witness? Seeing none.
Thank you.
Next witness in support, please come forward. Anybody? Going once? Oh.
Good afternoon. Camelia Peterson with Americans for Prosperity. And I think that, this is probably something that a lot of us would agree with, and in light of the recent Chevron ruling that was talked about. So I think that this is a matter in many ways of an ounce of prevention is worth a pound of cure. And so this is the Committee on Government Efficiency, and I think part of government efficiency is clarity in the statute, and we support this, think that SB 221 will provide that clarity as to the proper role of the judiciary with regard to state agencies, and that is clarified within statute. And that clarification means that the interpretation of statute and agency regulations is without bias toward the government and with bias toward individual liberty in those cases whenever there is genuine vagueness in the law. So I appreciate your time, and we are here for support of SB 221.
Any questions of this witness? Seeing none, thank you for being here today. Next witness in support. Going once, going twice. Anyone here in opposition? Seeing none, anyone here for informational purposes only? Please come forward.
Good morning, Chairwoman Coleman, Vice Chair Hudson, and members of the Missouri Senate Government Efficiency Committee. My name is Nina Marchese, and I serve as the Director of the Judiciary Task Force at the American Legislative Exchange Council. I appreciate the opportunity to be here today to provide ALEC's nonpartisan research and analysis. Thank you for having me. The American Legislative Exchange Council is America's largest nonpartisan voluntary membership organization of state legislators dedicated to the principles of limited government, free markets, and federalism. Comprised of nearly a quarter of the country's state legislators and stakeholders from across the policy spectrum, ALEC members represent more than 60 million Americans and provide jobs to more than 30 million people in the United States. Members of ALEC's Judiciary Task Force, which I run, include state lawmakers and policy experts who handle issues ranging from criminal justice reentry and recidivism to civil litigation and administrative state reform issues. A large part of the task force's portfolio also includes protecting the separation of powers and co-equal framework established between our distinct three branches of government, which is why I'm here today. So to begin, I'd like to touch on our members' experiences with judicial deference reform. Regarding opposition to eliminating deference, the most common obstacle our members encounter is the fundamental misunderstanding of the issue and what it really is. Additionally, there are claims that conservative parties and or courts seek to benefit and are given a leg up in the courtroom when deference is eliminated. However, because of its procedural nature, deference provides no benefit to any group or political party. But prohibiting deference does promote justice and upholds our nation's separation of powers. So what exactly is judicial deference? It's the practice of a court deferring to the executive on something courts have long been assigned the executive privilege and responsibility to handle themselves, questions of law. With deeply set roots, our legal system has determined that when the law is ambiguous, objectively or arguably, the judiciary will be the adult in the room to determine what the meaning of a law is. Judicial deference obliterates this legal framework our nation is built on by instead having courts defer to bureaucrats' interpretations of the law when an ambiguous statutory matter is afoot. Deference takes one of two forms. It's either mandatory or voluntary, the former forcing courts by law to defer to agency views, with the latter simply allowing for the practice. Missouri's particular deference status is unclear, as its courts have held inconsistent rulings on the matter. What is clear is that this legislature has yet to prohibit the practice. But what is so wrong with courts deferring to executive agencies? Employees in state agencies often dedicate their careers to developing the subject matter expertise which they use in statutory enforcement responsibilities regularly. Further, some may have a deep knowledge of the policy issues the judges are tasked with interpreting and ruling on. Regardless, courts deferring to such employees create three major problems. First, it increases the power and unjustified lawmaking abilities of unelected bureaucrats. Each senator on this committee endures the adversarial struggle of justly achieving their political power through an election, earning lawmaking authority through the consent of the governed. One of the core purposes behind our representative democracy is to ensure that those who make our laws are accountable to the public which they govern. Unelected bureaucrats are not. Nonetheless, they hold immense rulemaking powers which govern and affect the lives of Missourians. Allowing subjective agency interpretations of a law to prevail over that of a judge's effectively increases bureaucracy power because it teleports their preferred reading of this legislature's laws into the courts and into the law where they might have otherwise died in a government building cubicle. Second, judicial deference abdicates judges of their exclusive responsibility to interpret the law. Judicial review is a long-established power and core function of the judicial branch in both state and federal systems. It is well equipped to interpret the law when unclear and has many tools at its disposal to do so. Most importantly, legal interpretation is a responsibility exclusive to the judicial branch. While agency expertise on policy issues may serve as potentially valuable insight and resources to actual lawmakers like yourselves, their views have no business determining judicial decisions.
Thank you so much for your testimony. We have, does anybody have any questions for this witness? Okay, do you want to wrap up your thoughts? I don't know.
Sure, I can close real quick,
Okay,
if
that'd be
that's
great.
all right with the
Thanks.
committee. Thank you, Madam Chair.
And if it looks like you have something written down, if you want to give it to us, we're happy to distribute
Sure, I'm
written
happy to
comments to the
distribute
committee.
materials. Lastly, I'll just say that deference it removes the primary function of our judicial branch that it's supposed to exercise, and what society has deemed that it should exercise is interpreting law when unclear. That is an exclusive role of the judiciary. It is not up for unelected bureaucrats to decide, and it gives parties an unfair advantage in a courtroom where they might otherwise expect a level playing field. And so for that reason, we'd like to share our insight and nonpartisan research and analysis with the committee and encourage you all to revisit this issue like many other states in the country are doing. Already 8 states have introduced laws this session to reform their deference practices. So we encourage you all to join them as they reconsider this very important issue. So thank you.
Thank you so much for your testimony. And yes, go ahead, Senator.
So are you testifying for informational or for support of the bill?
For informational purposes.
Okay, thanks.
Any other questions for this witness? Seeing none, that will conclude our hearing on Senate Bill 221. Thank you, Senator Schroer. At this time, a little bit of housekeeping. This is always tricky. We want to invite the Tax Commission to come up. I'm going to kick things off, but then Vice Chair Senator Hudson is going to take over. I'm getting word that I'm almost needed and next door to testify or to present my bill. So I wanted to thank all of you for making yourselves available and coming in. One of the things that this committee has been tasked to do is when there's a lot of concern or confusion about what role an agency and department or a constitutional entity like yourselves is doing and how things are happening with a variety of different topics to come in and get more information. I have to tell you, I didn't know that it was a constitutionally established entity until I started preparing for this hearing. And so Senator Hudson is going to be taking over for me. But before I kick it over to him to go present my bill, I was hoping that you might be willing to just share a little bit about the role of the commission, how it was established, where your constitutional authority and statutory authorities lie, and how you work through issues, because I think we need some leveling information before we start asking more information. And I'm not sure which of you would like to.
I'll kick it off.
Thank you, Senator.
Madam Chairman, thank you very much for the opportunity to be here, members of the committee. For the record, I'm Gary Romine, Chairman of the State Tax Commission. With me is Commissioner McGinnis, our Chief Legal Counsel, Greg Alsbury. We also have Dan Hutton, our Legislative Liaison, and Stacy Jacobs, our Office Administrator. Our responsibility, we have 4 departments. Local assistance, that department's responsible for being out in the field, working with the county assessors to do their job. State assessed properties is another division. They're responsible for utilities, railroads, and airlines, the big ticket items for state assessed or centrally assessed properties. Stacy's our office administrator. She's responsible for making sure we stay in line and on time with things. And then our general counsel is primarily responsible for the appeals process. And constitutionally and statutorily, we've been set up to have governance over the
Senator,
county.
I'm going to hand the chair over. I'm getting word that they're needing me. Thank you. I'll be right back.
Very good. We are charged with the responsibility of overseeing the 115 taxing entities, 114 counties in the city of St. Louis. And that's our duty and responsibility under statute and constitution. And we're here to answer any questions and to be of whatever service we can be if there's particular questions we need to start with.
Thank you very much. I appreciate that. Appreciate y'all being here and willing to answer questions. Before Madam Chair had to leave us to present a bill, she did leave me with some questions. So if that's all right, I'm going to just kind of read off of here some of the questions that that she has, and maybe you all can enlighten us with some answers. The first one is, why did the State Tax Commission change the form that has been used to assess pipes for property tax purposes since 2013?
This has been an ongoing issue for several years. It's been a hot topic for the 5 years that I've been on the commission. And most recently, we had appeal that's coming up, application for review. One of the utility companies asked that the tax commission make a commitment to try to create continuity across the state in how pipes are to be assessed. So we ask our general counsel to do the research to find out what is the appropriate life for pipes, and he's got an extensive preparation here, and if you don't mind, it would really help answer a lot of this if we could use his answers, and he's got a handout he can give to you as well as go over some of the highlights of that.
Okay.
He has the information to answer that question.
Okay.
Mr. Osbury.
Okay, well, thank you. Well, so the time frame I'd like to directly talk about. By the way, I'm Greg Alsbury, Chief Counsel. That's ALLSBERRY. I kind of need to talk about a time frame from 2013 and going forward. Around that time, 2012, 2013, assessors were apparently having trouble in assessing pipelines. Some pipelines are transmission lines, but some are distribution. And county assessors are responsible for assessing the distribution gas pipelines. And as you can imagine, assessing an underground gas pipeline is not the easiest thing. And there are a variety of ways that one might go about doing it. So the assessors back then, a number of them were asking the commission to suggest for them a methodology that they could use. It would be relatively simple, relatively inexpensive, and that they could use consistently. And so the commission back then first promulgated its natural gas form. And by statute, there is a certain methodology that follows the IRS guidelines makers. And for whatever reason, the commission back then decided that it would also follow the 20-year, just like with personal property, would follow the 20-year scheme for pipelines which are assessed as real property. So to that extent, to the extent that the commission tried to make life simpler for all parties and more uniform, it achieved that goal. Yes, sir.
And I want to interject. This was a suggestion. Let me read the last paragraph so that it's clear what the commission back then did. The following forms were prepared as a guide to assist the assessors in gathering data. Please note that these forms are not a requirement, but merely represent a guide for the types of information to be gathered to assess natural gas companies. As he goes through this process, I just want it to be understood that 20 years was convenient as a template. Counties have their own right to do their own assessment within their counties. And we tried to do the research to find out what the mentality was, but the best we can do is use this statement here to show that this was a guide. If a county wanted to go up to more years, they had the authority to do that because they have the authority to assess as they see fit within their own county.
So maybe you touched on this next question if you're in your answer, but I'm going to go ahead and read it. Why did they decide to increase the tax liability of every utility customer by changing the depreciation method?
The key motivation there was to be consistent and uniform. Some of the research that Greg did, I'm speaking for him here, but in doing our state assessed pipes, that's on a 50-year program, basically. If you look at the PSC, life is determined in 50, 70, 80 years of life. Consistency shows, based upon some of the testimony, some of the research that Greg did, the average life of pipe is 50 years, some 40, some 70. So again, by process, the average life of 50 years seems to be a common denominator. As most know, while I was in the Senate, I was very much a ratepayer supporter. And I wanted to contend to be that throughout my life. But at some point, we had to make a decision that if we're going to be consistent in how we assessed assets, then we need to stay consistent with how they're being done through the IRS, through the PSC, through state assessed properties, and 50 years became the number.
Was there a public hearing on this, and was notice given for that hearing?
There was not a public hearing, but like I said in the beginning, with all the appeal processes we've been through, the applications for review, both parties have been engaged in this discussion for many, many years. And so it's September, I believe, was when we received the application for review, asking to come up with a decision that was create a consistency across the state. That's when we asked Greg, and by December, he came up and made a recommendation on his findings showing that 50 years was the most appropriate life for those assets.
So this decision has increased taxes on utility users. Did the commission consult with other representatives, taxpayers, assessors before the decision was made?
We did not.
Okay. Under what authority did the commission take this action? Question number 5.
Again, that's our responsibility to create the assessment process that's most appropriate for statewide use.
I got one more question. There are several tax disputes pending before the State Tax Commission regarding the assessment of pipes. The new form appears to represent the position taken by some county assessors in these contested cases. First, why did they make the decision to, in effect, endorse the position of one party over another in a contested case that the State Tax Commission is deciding as a quasi-judicial entity? Second, do they have, I guess I said one question, there are 2 questions at least within this question, so my apologies for misspeaking earlier. Second, do they have that authority, and is that proper to take one party's side that has been presented in a contested case they will be deciding?
Again, our responsibility was to ascertain what value was most appropriate. We did that independently of the appeals that were before us. We did it by the research that Mr. Alsbury did, and that's how we come to our decision, not based upon the, I guess, appeal of either party at this point. We know we have several larger counties in the state that have been doing a 50-year life, so it's going to be tough for this legislative body. We have a court's decision that does not mandate how many years, but it does say that if we're going to talk about depreciation, we need to be consistent with it. So the courts haven't said we have to stick with the 20-year schedule, but they do recommend that we create a schedule and honor it.
Now, did I understand you correctly earlier to say that county assessors have the ability to assess utilities differently should they choose to do so?
They have that latitude, yes.
They have latitude to go up or down, either direction.
Correct, but I mean, when it comes to the appeal, then that's when it's time for us to decide whether or not they made the right decision. So there's that check and balance as we go down the process, yes.
Okay. Are there any questions from the committee for the State Tax Commission? Senator Bean.
Just out of curiosity, what was the thought process in not having a public hearing or having public? I'm just curious of the thought process that you all went into.
Can I take a stab at that?
Yes.
Yep. You mentioned contested appeals before the Tax Commission, but there is one fact that's not contested. All parties agree that these pipelines last at least 50 years. Nobody disputes that. The pipeline companies' depreciation studies that they have filed with the Public Service Commission show a life of 60 to 80 to even 100 years. So, and that was the case back in 2014, 2015. It's the case now. That really hasn't changed. In the applications to the Federal Energy Regulatory Commission, when they have applied for authority to lay new pipelines, they submit their depreciation studies and they show a life of at least 50 years. So no one is claiming that they only last 20 years. And so it's when we are faced with arguments of assessors, you're making us follow this 20-year schedule when everyone agrees that they last at least 50 years. That's kind of a hard argument to ignore.
And to complement that with your question is, based upon the hearings, the appeals, the applications for review that we've gone through, we've had an opportunity to gather all that information to make an informed decision on what 50 years or what the depreciation life should be. And so that was our thought process, is we had collected enough data that we felt like we could make a proper decision.
Okay. One other question on the 50-year life expectancy of a pipeline. Is that before you see, I'm just curious, before you could encase those with other polymers or whatever? I'm getting curious here because I know you can encase pipelines and extend their lifespan. I'm just curious, did you factor that in?
We did not factor that part in, but I mean, once they're starting to be encased, they've probably been in the ground 60, 70 years before the encasement process. So again, more than the 50-year number that we're talking about.
I'm just curious. Thank you.
Any other questions from the committee for the State Tax Commission?
And
Go ahead.
Stacy did remind me that we did have, it was not a public hearing, but we did have a public meeting. The SDC posts our public meetings on the door and on our website, which is not necessarily required, but we do post our meetings that we're going to have, and one of the subject matters was discussing the life that we were going to apply to pipes. So we did have a public meeting in that regards. And
Thank you. Thank you for that clarification. I don't see any further questions. All right. Well, I'd like to thank you all for being here today. In a past life, I was a county assessor, and there were some days I liked to see the State Tax Commission coming, and other days I may have not liked to see the State Tax Commission coming. But I certainly feel like I've got an appreciation for the work that you do that maybe not everyone shares because of having not worked in the property assessment
well, thank you very
field.
much for the opportunity to be here. And if you need us to come back, we're more than happy to do that with any follow-up. Or if you have follow-up questions and we can respond from our office, we'd be happy to do that as well. And if you don't mind, if Mr. Alsbury can give you his handout on the details of the research that he's done to get to the 50-year life, we'd appreciate that opportunity as well.
Okay. All right. Happy to look at anything you want to give us. So thank you very much. Thank you for being here. I think what this committee is going to do right now is just stand at ease for a bit because we do have one more bill to hear. However, that bill sponsor is not currently with us. So stand at ease, please. right, the Senate Committee on Government Efficiency will now come back into session, and we are going to hear Senate Bill 223, sponsored by Senator Coleman. Madam Chair, welcome. Please begin when you are ready.
Thank you, Mr. Chairman. That's not very efficient, I suppose, to have to stand at ease while I'm finishing presenting a bill on the other side.
You can't be in two places at once, Senator.
For the record, Mary Elizabeth Coleman, State Senator for the 22nd Senatorial District. Senate Bill 223 is an interesting bill because I'm asking to put into statute something that is already illegal. This body, the General Assembly, has fought for parental rights over the last, at least the time that I have been serving, and there's federal law in place requiring that if children are receiving surveys regarding explicit types of questions, that parents have an ability to opt out. This piece of legislation rises from a situation in which was actually on the front page of the Post-Dispatch today. Again, one of our school districts in our state has decided to flout those rules, has chosen to ignore those rules, and only when a piece of litigation, of all things, a sunshine lawsuit, did the school decide that they were going to no longer allow this to be happening. One of the clubs in the Kirkwood School District put out a survey about the craziest places that students had had sex. And they received a number of responses to that question, and that those responses were then published in the school's yearbook. It made national headlines. People were horrified. And what we have found is that without teeth, without a way to actually enforce it, the moderator of that club, the administrators who had violations of the statute, federal and state statutes, were not enforcing it. So Senate Bill 223 creates a private cause of action with a statutory fine for when this privacy laws are violated. It is beyond the pale that our students should be asked these types of explicit material, these types of questions, and in fact, it is already against the law. But it seems again and again our political subdivisions are only willing to act when there is a private right of enforcement that is in the hands of the people, and only respond to litigation. We're going to hear, I think, as a committee, time after time, when there's statutory laws that are put in place and people ignore those laws. And what do we do when that happens? And this is one proposal of what do we do to make sure that those state statutes are followed. Thank you, Mr. Chairman.
Thank you, Senator. Appreciate that presentation. Are there any questions from the committee for the bill sponsor?
I have a question.
Senator Carter.
More of a comment maybe than a question. Thank you for this piece of legislation. I think it's a great piece of legislation. In regards to the opt-in or the opt-out, I'm wondering if you might be open to the conversation about opting in. What happens, or what I've seen happen, and there was a situation actually with my son who has special needs that was going to school, and we had asked that any of the surveys or any information that he was offering would be sent to us. Well, what happens is there was a policy at the school level, and I think this was a statewide policy that school boards adopted, that if the parent didn't sign that opt-in form, then it deferred to the superintendent or the teacher. And so it was astonishing to see that policy implemented and in place in my school district. I would love to see these surveys and some of this information be more of an opt-in, where nobody can, basically take that away from the parent, and the parents have to opt in before the questions or the surveys are presented to the kids.
Thank you, Senator. I think that is a problem. One of the things that we have seen is that opt-outs don't always work as well as an opt-in situation. Unfortunately, I am a little bit afraid that might create a broader fight, because that was such a big fight to even get across the finish line, and we were a part of that, allowing people to be opting out of. So let's have further discussions about how we go forward with that, because I don't want to let the perfect be the enemy of the good, but I agree entirely. People should have to opt in rather than being able to opt out. And a large part of what happens is these policies are already in student handbooks, they're in employee handbooks, they're in board packs. Everybody agrees, but then when the violations take place, the boards don't seem to act on the employment violation. I think we're going to hear some testimony against the bill because they don't want their members to be held liable. But these things are already federal law. These things are already state law. And when we have rogue state employees or employees of our school districts or other political subdivisions who are violating the law, at some point people have to be personally responsible for their actions.
Any other questions for the bill sponsor? Seeing none, is there anyone here to testify in favor of Senate Bill 223? Seeing none, is there anyone here to testify in opposition of Senate Bill 223? Seeing none, is there anyone here to testify for informational purposes only? Seeing none, that will conclude our hearing. Senator, do you have any closing remarks?
Thank you for waiting for me. I appreciate it.
I'm glad to do it. Thank you, Senator. All right. And with that, the Senate Committee on Government Efficiency will stand adjourned.